Just checking in to see, has everyone finished reading number 6? Okay, so I found this particularly confusing. Who wants to start on any amendments to number 6?
Madam Chair, or maybe Toby can clarify, workshop B said the entire last sentence incorrectly included and will be, should that be part of our definition? Whether a particular factual legal.
Is your mic on?
Oh, no, it is. I'm just not close enough. Sorry.
Okay, are we back on IT?
Yeah.
Okay, go ahead.
Workshop B suggested that the last sentence should not be included about estoppel and is that accurate or is that part of our definition?
Okay, I will try to lawyer it down, but I could talk to you for an hour about this and I won't.
Before, if I could just add a codicil to the question, maybe Jackie, you were there. The way that's worded, it says it will be, did workshop B feel that someone had agreed to take that out? It says it will be modified.
I'm happy, I can explain it.
Okay, thanks.
Okay, so in looking at SB2 when it first came out, this perplexed me because I'm very familiar with the law on collateral estoppel as it would apply to this proceeding. I've used it many times as a civil litigator. And let me just tell you very briefly, in very brief legal terms, the idea would be when the commission gets these cases, it may very well already be that there has been a legal proceeding where some of these issues have already been heard and determined. So in state practice, for instance, I'll tell you, we have in state service, if there's an adverse action against an officer, it can go to the state personnel board. The state personnel board can render a decision and there can be factual findings and determinations. So it made perfect sense to me that the legislature would include a provision that gave respect to the collateral estoppel impact in this legislation. I could not for the life of me figure out why it was put in this subparagraph, because it should be a standalone. I would think that unless the legislature intended collateral estoppel only to apply to this subparagraph, that it should be in a separate paragraph. And it just flummoxed me as to why it was there. And I put it on my list of one of the many things to try to see if I could figure out why the legislature did it that way and what impact that should have on how we interpret it as we go forward. What we got in the workshop was somebody who had been involved in the groups that were working with the author's office to get the legislation passed. And obviously, I can't rely on this, it's hearsay and all that stuff, but I thought it was interesting what that individual's perspective was, that the legislature it was basically a proofing error, right? That it did not belong in this particular subsection, that in effect it was intended to be, and this is what made sense to me, really standalone. So I don't think that we should consider, if at some point a court tells us that the collateral estoppel applies to this subdivision only, then that's fine. The court can say that, but I'm not sure that we have to worry about the collateral estoppel issue. Let us lawyers worry about that. From the standpoint of the commission, I think the real question is, what does the commission think about the first sentence about acts that violate the law and are sufficiently egregious or repeated? But to the extent that the collateral estoppel applies, it would be just as I've described. If there has already been a previous legal determination, and that I could give you the legal bases for when collateral estoppel applies and it doesn't, there has to be basically the same parties and the same issues, and there has to be an identity or motive or opportunity to defend in the prior action. So there have to be all kinds of things that have to be met. And it can be used offensively or defensively. There's all these things lawyers talk about on collateral estoppel, but all that means is that there may be a prior proceeding that would bind the commission. But again, I think the collateral estoppel issue is a separate issue, and the real question here is, what does the commission think about the first sentence? Anyway, I don't know if that helped or hurt, but that's my view.
That helped me. I'll just ignore the second sentence.
Okay, so let's, I agree with Toby. Let's now consider that first sentence, which is enough in itself to be considered. So acts that violate the law and are sufficiently egregious or repeated to be inconsistent with the peace officer's obligation to uphold the law or respect the rights of members of the public as determined by the commission. Okay, so the things that start coming in there are, how do you define egregious? Do you bother to define egregious? Does that include misdemeanors, infractions? What about, domestic violence can be a misdemeanor. Battery can be a misdemeanor. Sexual battery can be a misdemeanor. So there are many serious misdemeanors. We have some things to talk about. So let's start with, does anyone think that we should just leave it alone or add something? Thoughts?
Kind of feels like they want us to add something because it says as determined by the commission.
Say it again.
It feels like they want us to add something or to define it because it says as determined by the commission. And I don't know how to define it.
Mhm.
What is egregious, what is repeated, and how does it come to us? So if it's a DUI, but it's the officer's 10th DUI, it's incumbent upon the agency to bring it to us because these aren't necessarily going to be reported. It's kind of a catch-all, but it doesn't send the fish our way. We're supposed to catch them, but it doesn't actually stock the pond, so to speak.
I think we'd all agree that we want to know that it's sufficiently egregious, but how do we even begin to define that term besides a case-by-case basis? Manny, some thoughts about this?
I do not, but I do have a question.
Okay. let's have a
Unrelated to that, and I can wait.
No, go ahead.
But does the act have to actually violate the law? In other words, a conviction? If they violated the law, but they were never charged, it's clear that they did something. That's a question, I guess, for you, Toby. I don't know if did the violation of law,
Yes.
it had to have been a conviction? And if so, I mean, obviously, if it's a felony, it's a simple answer.
No. The conviction question is separate. That's a separate ground for decertification, independent of the serious misconduct. So, and I could talk to you for 2 hours about section 1029, but I won't. So no, this does not require a conviction. So I think this is in some ways a catch-all that is independent of the question of a conviction, where you have an act, which is pretty clear, that violates the law, and presumably that means a felony or a misdemeanor. I guess there's a question. It could be an infraction. It could also be, presumably, I suppose, a violation of civil law, and sufficiently egregious or repeated. But then really the question in terms of as to be inconsistent with the peace officer's obligation to uphold the law and or respect the rights of members of the public as determined by the commission. I kind of see that as not necessarily that the legislature is saying that we need to in much additional detail flesh it out, but that in this, as with the other areas of serious misconduct, that ultimately it is the commission that will determine if the act is in fact sufficiently egregious or repeated as to be inconsistent with the officer's obligation, et cetera. So let's say, for example, you have an officer that has 5 infraction parking tickets on the car. Is that something the commission would determine is sufficiently egregious or repeated as to be inconsistent with the officer's obligation to uphold the law? Or if you have 500 parking tickets, is that something that might be inconsistent with the officer's obligation to uphold the law? So we can certainly talk about whether or not we should flesh the regulation out a little bit more. And then I guess really the other question is, with the language as it is it just, as with all of these, the question of when the facts come to us, it's kind of like Commissioner Dudley said, like it's like pornography. You'll know it when you see it.
I tend to think that this one is I don't even know how we begin to make this any clearer. I'm open to anything though. Yes, Commissioner Long.
I'll just throw it. I think this is a good one for the Donald Doctrine. It seems to me that it was written as a catch-all and designed to be case by case, and that to make it more specific would actually, to me, as I read it, would go actually against the intent of it, which was to
That was my
catch-all.
impression.
Here's a catch-all for you guys if you need to put something in here.
Completely agree.
I think I think Toby and I also agree with that. I think it is a catch-all. It's when we all, as a group, see something that we think is particularly egregious and it doesn't quite fit into a category. Anyone want to change this? Okay, then I think we leave this as is. And your question was?
I'm just looking over at Maria and Jackie. Obviously, this is going to be a challenging one for us to execute on because it is so open-ended. Jackie?
Yes, thank you, Manny. So I will just represent to this body that this particular one of all of the 9 was the most discussed and unclear because of the ambiguity based on the language. And I do understand that it was there for an intent like that. However, I think at a very minimum, we should at least attempt to define what egregious is for purposes of not only the field to be able to interpret this, but for us to be able to bring processes and cases forward to this body. So I would suggest we try to go a little bit further if possible.
You would suggest what?
That we try to expand on this with the definition of egregious at a very minimum, please.
Well, if we want to consider expanding upon it, we can certainly list certain penal code sections. We can say broad things like all felonies. We can say all misdemeanors of domestic violence, blah, 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 blah. So I don't know that there are going to be any English words that are going to help us with egregious. All I can think of is, literally penal code sections. Thoughts?
Yeah, you can't start listing sections. One, felonies filter to the top anyway because the firearms issues, so there's domestic violence in those. But if you start doing penal code, you got to do health and safety code, business professions code. You've got every code possible out there. Plus, what if it occurs in another state? They're on vacation, they get arrested in Nevada for something that is serious, but isn't a code in California. I know that staff would like it defined tighter. I just don't know if we can. I think it's one of those that's so broad that we just have to support staff when they come back frequently to say, this is what we're running into, issues we're running into. How can you help us out? Throw us a lifeline.
If I may, one of the things that lawyers do when we are attempting to interpret statutes is sometimes we look to plain language and just definitions, commonly understood definitions. I'm just looking at the definition of egregious, and this just came off of because you get different dictionary definitions. Definition of egregious: conspicuously bad.
I guess from the staff perspective, when we start reviewing these things, I would imagine if we get something that comes in, our approach should be to try to link it to one of the other definitions first and not, right? As opposed to using this as the first starting point. And then if there's nothing and it's egregious, which we don't know what it is or what that means, then we go down this route, but it should not be the starting point for us.
Yeah, and I think the issue with this, in my vision, is if an agency took the time to start an IA process on someone for violating a crime, then we need to look at it, right? Because they've done it. Because what may be, for example, petty theft. We terminated an employee for shoplifting because of the nature and the conduct during the shoplift. One for hit and run that maybe somebody might not think it was egregious, but within the agency, when you start peeling back the investigation, you realize, no, that was the right decision. I think the concern long-term for me anyway is what about the agencies that aren't investigating stuff? That should have done an investigation, just ignored it. That'll be the bigger issue, but it's on every one of these that they didn't initiate a complaint. And that's that data stuff that Commissioner Ewell was talking about, and the things that the staff's going to come back and saying, hey, we're getting word that agency X is not reporting to us. In fact, they just stopped investigating things so they don't have to report to us. I think that's the bigger concern for us. I think this one will flush itself out. It's just going to be hard, and we just need to be willing to throw the staff a lifeline every now and again and say that's all right. We understand and we can help out with it.
think egregious is such a difficult word because of the subjectivity of it. You know, and in thinking about the racial profiling curriculum I worked on, you know, we would hear stories about a parent who was driving and they were pulled over and things were said, and it was extremely traumatizing to that child sitting in the back seat. And so then you ask any parent and they would say that was egregious. It affected the child the rest of their life, but it was words. So I don't know how we can do this.
May I?
Please.
Please. So some of the suggestions we received during the workshops, and just for your consideration, certainly not my opinion, but to give more weight to the seriousness of offense being felony over
I'm sorry,
misdemeanor.
slow down and speak louder.
Sorry, I do that all the time. So part of the workshop, we received some input from the different groups. Some of the input included evaluating, putting in tools of evaluating the offense, if you will, to include giving more weight to felony charges versus misdemeanor charges. If there's a rehabilitative factor involved, should that be taken into consideration? Corrective disciplinary actions, can that be used as a factor to consider, if you will? Just throwing that out there as an option for you all, if you want to consider that.
Are you talking process to bring forward to us? Is that what you're looking at? Or process for the agency reporting to you?
Both would be the answer to that, but primarily so that more for staff to evaluate it once we receive this. So is it the commission's opinion or preference that we put more weight on a felony criminal act than a misdemeanor criminal act? Or if somebody has already shown that they are able to have rehabilitative options available to them, do we use that in determining whether or not that meets this definition and bringing it forward to you as an actionable item?
Jackie, if I may, I had certainly assumed that one of the things that the commission would have in terms of the determinations that the commission makes kind of at the end of the day on any given fact pattern in terms of whether or not it warrants a suspension or a revocation or no action would be things like rehabilitative factors and the severity, you know, all of the sort of the multi-factor tests that commonly tend to be looked at in determining essentially punishment. I mean, I think to me, what I see in this legislative language is there's the first part of it, which is it's got to violate the law and it's got to be sufficiently egregious, serious, whatever, or repeated enough. But then it also has to be inconsistent with an officer's obligation to uphold the law or respect the rights of members of the public. And that is what I see as sort of the key. So I understand your desire to have some guidance, but it also strikes me that really what the division is going to be tasked with at the beginning is the question of, okay, you've got some acts, and the question is, are those inconsistent with an officer's obligation to uphold the law or to respect the rights of members of the public? And if so, then it's a question, does it violate the law? Is it sufficiently serious, egregious, however you want to say, or repeated? But all of those things then also has to be inconsistent with the officer's obligation to uphold the law. And so I understand the point you have, which is that staff doesn't want to just be willy-nilly making the determination, but it really is. I mean, I think if we were going to look at further defining things, I don't see it as much necessarily on egregious. I think we could probably figure out what is egregious, but the question is what's inconsistent with the officer's obligation to uphold the law or to respect the rights of members of the public. So.
Commissioner Gordon?
I'd like to offer to look at it a little differently.
Okay.
Versus looking at defining the definition more clearly. How about we look to termination cases? So if a department, and I don't know what the language looks like, I'm just spitballing.
Right.
If a department has terminated an officer for any section that doesn't fall within the others, that should come before the Commission for Decertification. Because anything that, you know, it's egregious would typically be something that they were terminated for. So versus looking at trying to define egregious, you know, someone is convicted of a felony crime because there are, you know, and if you look at workshop A, you know, government code does talk about the independent disqualifiers. You know, what disqualifies you, convictions, you know, what prevents you from carrying a weapon, you know, and so I think if we looked at and had agencies submit cases that were termination cases, I think that would make staff's job a little easier because now you're not, you know, you're not looking at all sorts of things that depending on the department, they may think is egregious. You know, going back to, I think it was Rick's comment about, you know, that petty theft, that because of all of the different things within the investigation, make it where you're terminating that officer. Well, I think that's a case that we want to see because we want to see that officer more than likely decertified. So I think maybe in versus defining the definition, we figure out a way to work this into what that definition is versus trying to further clarify, you know, what egregious and those type of things are. That's just my suggestion on how we could maybe help staff and help the field as well, because I think that that might satisfy both sides of that.
Commissioner Gordon, I think you're assuming things about other departments that may not necessarily be true. And I think that having done this work for 32 years, sometimes something isn't a felony, sometimes something isn't terminable, but I'd call it egregious. And that's why I think we're going to keep banging up against the wall, because the reason we created the decertification process the way it is, and the reason we didn't just rely upon chiefs was because we wanted to make it broader. And I think that gives us the broader. So you're not suggesting, I assume, that we, in terms of this area, we only look at termination.
No, I'm
You're
just saying that's a
something-
base. That's a baseline as to,
If they were terminated, then there's an assumption that it was egregious.
yeah, I'm just saying that that's a baseline, because I completely agree with you that not every department operates from the same place. I'm not disputing that fact whatsoever. I'm just trying to create some sort of baseline that I think for staff and for the field would at least get this, and I think this is the one we talk about what's going to come back and be redefined in the next 18 to 24 months. This is probably that section that will cause the most, you know, loss of sleep in most conversations, quite frankly, out of all the sections. I'm just looking at a baseline of how do we capture, you know, and make sure we're getting those most egregious cases, but also, you know, we know that trying to define that word and figuring out what that means is going to be very difficult. So I'm just saying that that would be at least the very minimum to me.
Okay, Toby?
And if I may, Commissioner, you may know this already, and if so, forgive me, but there is a very, very clear procedure set up in SB2 for the required reporting that agencies are required to do to the commission under 13.510.9. And so agencies that employ peace officers are required to report within 10 days any of the following events. And it includes termination or separation of a peace officer, any complaint, charge, or allegation of conduct against a peace officer that could render the officer subject to suspension or revocation, any finding by oversight boards and so forth that the individual engaged in conduct that could render an officer subject to suspension or revocation, and the civil judgments, just a number of things. And then also the final disposition of any investigation that determines that a peace officer engaged in conduct that could render the peace officer subject to suspension or revocation of certification by the commission. So there already does exist a I suppose you could say somewhat robust reporting requirement. And then the question is, when the division gets all of these in, then it has to somehow figure out once it gets, because it may very well be that an agency has terminated an officer for a reason that was perfectly acceptable to the agency and was right, violation of policy or whatever, but that does not necessarily rise to the level of one of the 9 specific issues that the legislature has given the commission for decertification. So I do see the reporting a little different, because reporting is certainly one question, but then we're going to get a whole bunch. And then the question is, when we get it, how does staff figure out, well, okay, here's a fact pattern. Is that inconsistent with the obligation to uphold the law or respect the rights of members of the public?
I think what Officer Gordon was saying is not inconsistent with what you were saying. I think she was saying if the report is the person was terminated, that is a bright line for staff to say, perhaps this falls under the acts that violate the law, not the reporting issue. Yes. What other thoughts and comments do folks have?
I do have some
Yes.
clarification because you could have a termination case that's not even based on the law.
Correct.
So is Commissioner Gordon saying, if there's because it says violate the law and blah, blah, blah. Is it a violation of the law and she's looking for a termination case?
I think
And
what
then,
she's saying, but she can speak for herself, is that when we're looking for bright lines, that's a bright line we should consider, not an exclusion of anything else.
correct. And then also, I do, looking at felony or misdemeanors, I agree with the chair that there are things that that may have been filed as a felony, they pled down to misdemeanor. But in the eyes of the commission, they may see that as egregious, and that's pretty common in our court system. So I don't know if I agree with adding the definition of felony versus misdemeanor.
Yeah.
I know it's very broad, it's very difficult for the commission, I get that. But I can think of misdemeanor cases that people would be shocked that it was a misdemeanor. So.
I agree. Yeah, as an attorney, I wouldn't want to make that distinction as a prosecutor. Okay, so where we are is no changes or possibly adding something to egregious along the lines of something that results in termination. So anybody want to add anything here? Okay, then we're not adding anything. Donald, you want to add anything to the not adding anything?
No, ma'am.
All right, on to,
Madam Chair, if we may we kind of wordsmith where you would put that termination language in there? It
we didn't,
obviously,
we.
you're
the
not
group
going
did
to?
not- Did not want to proceed with
so
that.
that's just a procedural process thing for post staff. Okay,
One of the things to be considered in the toolbox,
okay.
unless someone's added. I didn't think they did. Okay. Law enforcement gang. I wonder what police department we're all thinking about now. So somebody decided to put in law enforcement gangs. We don't have any of those in Santa Barbara, but they do exist. So please take a look at that, as well as the workshop A and B, and you're starting on page 7 and moving to page 8. Okay, does anyone want to add to number 7? And if so, what?
I would recommend that we leave it as is. It has way more than enough words.
Anybody disagree? Okay, leaving 7 the way it is. Okay, now on to 8, which only appears on page 8. Okay, this is where I get a little nervous because we have the police officer's Bill of Rights. And there is no duty to cooperate unless there are all kinds of hoops that we jump through. Toby, your thoughts on this?
Well, the legislation does take that into account, though, because
They
it
do.
says, for purposes of the paragraph, the lawful exercise of rights granted under the US or California constitutions or any other law shall not be considered a failure to cooperate. So I read that sentence as understanding that there are certain rights, such as the rights under POBRA, and that if an officer is simply exercising those statutory rights, then that would not be a failure to cooperate, which would result in decertification.
Can you give me an example, or can anyone give me an example of a failure to cooperate? And here's my question. So failure to cooperate is so strong that someone should be decertified. And it wasn't covered by any of these other issues. So one police officer sees another police officer do something, and they refuse to be interviewed about what it is they saw. Now, under POBRA, your thoughts?
Well, okay, I always get in trouble when I think out loud, right?
Okay,
So I'm just trying to think, and those of you in law enforcement who have done IAs, I'm thinking, for example, you might have a situation where an officer is subjected to an interrogation. That officer refuses to answer questions and asserts a Fifth Amendment right. And then in that case, they're given the Lybarger and the other admonitions that they are required to be given. So they've now asserted their rights, and we can't take action against them for a lawful exercise of rights under the Constitution. But then once they're given Lybarger, then they are ordered to then cooperate with the investigation and to answer questions under pain of penalty of insubordination. And if they refuse to answer questions, then they can be subjected to an adverse action by the employer for purposes of insubordination. I think I said that right.
you did.
So I suppose that's an instance of a failure to cooperation where the exercise of rights is not going to be something that we're going to consider and take against the officer, but it may be that the failure to cooperate with the investigation by not cooperating and giving a statement pursuant to the order of the department after having been given Lybarger and all those admonitions, maybe that's something that could be a failure to cooperate.
That's a great analogy. Other thoughts about this one? Please.
I suspect there's going to be some circumstances where an individual resigns or retires in lieu of an investigation and the person has not been interviewed. The investigation is just initiating. The person's no longer employed because they retired or resigned. They're no longer the employee of that department, so they can't necessarily be compelled to give a statement, administratively compelled to give a statement. What happens when that individual refuses to cooperate? The department now is mandated to conduct the investigation. So the person's now a private citizen,
Yeah.
and I suspect that will happen. I presume that will potentially be decertifiable based on what I'm reading here. They fail to cooperate. If I read that correctly.
Raise a good issue. Comments? Let's.
I do have another, let me throw one more wrench into it, and I guess this is for Toby. Toby, what happens in those instances when the person says, I'm going to invoke my Fifth Amendment rights and I'm not going to give you a statement, and don't take that as failure to cooperate, but I don't want to incriminate myself.
Right. Are you talking about a circumstance where an individual has already resigned and
Yes.
therefore is not a member of the department? So under those, and this is something I think actually was raised by the second work group, and it's something we really have to think through because POBRA is set up now in a certain way and the laws are set up with the understanding that cooperation can be compelled by the employer by virtue of that employment relationship. And if it does happen that Post ends up conducting its own investigations, and I know that's not the intent, but it could certainly happen, then we have to consider sort of how we are able to enforce our rights to, as with an employer, that the employer could say, under penalty of termination, we're ordering you to answer. So the question, I think this is what, I think this is what that group was getting at, the group B was getting at here, is that the idea was in that circumstance, maybe that's what Post would consider the failure to cooperate with the investigation. So whereas we're not the employer and we can't order the person under pain of insubordination, that perhaps the failure to cooperate would put an obligation on that individual, even though they're not employed by that agency anymore, to cooperate with the investigation for Post's purposes, or perhaps for the agency purposes. So in that same situation, the agency's doing it. When the agency speaks to the individual, then that individual's failure to cooperate with the law enforcement agency, although it is now not insubordination because the person is not employed and can't be, action can't be taken against their job, maybe that's the kind of failure to cooperate that could result in a decertification action.
Then what would you do if it was a Fifth Amendment issue? In cases like that, what the prosecuting agency do is they'll give immunity. We're not in the business of
Right.
granting immunity.
Correct.
So we're saying to this person, we're going to decertify you unless you tell us what happened. And they say, I don't want to tell you what happened because that violates my Fifth Amendment right. So that would then be a reason to terminate, according to this.
Yeah. Read a law review article.
I don't think so. Okay, see the problem? So thoughts? Does anybody want to add to this at all? Yes,
Just from the wording, doesn't it protect the guy claiming his Fifth Amendment rights?
Yeah, it absolutely does.
Yeah, so I mean,
The amendment cannot be-
right, so that's
Yeah.
kind of neither here nor there, right? That guy's protected as is.
Right, absolutely. I think the question that Joyce was raising, and it's appropriate one, is if the individual is no longer, and I may be saying this wrong.
No,
so
you're saying
tell-
right
tell
so
me if
far.
I'm
No longer
not saying it
about, right,
The person is no longer employed by the agency
right.
and invokes the Fifth Amendment right. And we then say, well, we understand, but we're ordering you to testify anyway. Do we have the lawful ability to do that under the guise of this? Notwithstanding the question of under the Fifth Amendment, they say, hey, wait a minute, you can't compel me to cooperate.
And it says here, the United States Constitution, so that's the Fifth Amendment. Deathly silent.
Well,
Leave it alone.
I'll just share this with you. Most of the people that I can't think of anybody that this didn't happen in, that resigned because of an investigation would have been decertified on one of these other sections. Nobody resigns just because I called in sick. It's because they're under criminal investigation and they know that the disposition is termination, so they quickly resign before the case can be completed, but now the cases have to be completed. So we're still going to get a completed internal affairs investigation, and then it's going to be one of these other sections. But I agree, once they resign from the agency, POVAR we can't pull a POVAR card. And they can assert their rights. And I think we'd fail if we tried to decertify them for lacking of cooperating just on that, but it's going to be one of these other sections.
How would that apply to a precipient witness as compared to the perpetrator? So the precipient witness is being asked to tell what happened. And that precipient witness feels that if they tell what happened, that they're in fact violating their Fifth Amendment because they're incriminating themselves.
That's a question for the lawyer when we look at the case. I mean, this is going to be one of those that Toby's going to be very busy with this stuff, and can they assert their right? Can they not assert their right?
Attorney of Santa Barbara.
There you go.
I think we're getting a lot of the legal stuff. What do you think? What do you think? What do you think? Like the egregious stuff. And where we at? But I can tell you, I can't think of a single case in my 33 years at the city that somebody didn't resign because there was some serious discipline going to happen, termination, that would have fit into any of those other categories, if not multiple.
Jackie, can you, or Maria, either one of you think of anything you think that we might be able to give you in terms of help with this particular paragraph?
No, as a matter of fact, both work groups didn't have much to offer in addition to this as well. So thank you.
I do think that we also have the ability to suspend if it got to that point. So we have that also until this whole thing came to fruition.
Yeah, I think, just to throw it in there, I think the person who didn't want to speak because they felt it violated their Fifth Amendment probably would also be able to fight this. Okay, so anything else on that? All right, nothing on 8. Moving into 9. Failure to intercede. That would be on page 8 and page 9. If you take a few minutes to read that, please. What's of note with 9 is it at the requirement of the present and observing. So this is a failure to intercede when present and observing as distinct or as separate from someone who goes to the bar that night and 2 officers are talking about what happened. And what happened was a terrible, horrible thing. But that person, the third person at the bar, couldn't have interceded because they weren't present and observing. So this is a very specific area of action. So thoughts?
Just a point of clarification. So the way in which I read this, it actually, the witnessing officer that fails to intercede actually is subject to more, potentially more than an officer who used the force because of the way the physical abuse section reads. Would that be correct, Toby, or am I off on when I read it?
Well, that's certainly something was brought up, that the suggestion that that person would have to have been found to have been remiss in the action of abuse. But I don't know there would be more. Toby?
A very good question. I honestly haven't thought about it, so I'd have to probably think about that for a while. But I think your point is quite likely accurate, that the legislature hereby saying that a failure to intercede when an objectively reasonable officer would contend that force was being used, it was beyond that which is necessary, maybe more than what is required for the officer that is themselves using excessive force that does not rise to the level of abuse. If I'm understanding what you're saying correctly.
Yes.
I think that's likely an accurate observation, but again, it is what it is. The legislature's given us what they've given us.
Just, I'm asking that to clarify, just so I have a clear understanding of what we're talking about when we're looking whether we need to add to the section.
I don't know. I'm looking back at physical abuse, and it does say including but not limited to the excessive or unreasonable use of force. So when we tie excessive or unreasonable use of force back to this, the language here is force clearly beyond that which is necessary. lawyers will be arguing about this language for years.
Commissioner Barsalo was talking about an event at lunch today about a bunch of officers are hands-on. Another one just comes onto the scene and tries to assess. Should I help? Should I not help? Should I intercede? How do you know? And I think officers are faced with that a lot, that they just roll on to an event. So in a case where someone who didn't intercede, from their perception, they were present and observing another officer using too much force, but had they come there 5 minutes earlier and seen that in fact they were taking a knife and a gun away from the guy, that wouldn't have made sense. So I do see your concern. Anybody have any thoughts about that? This is the last one. Now, one way we could mess with a little bit would be in the word clearly. So failure to intercede when present and observing another officer using force that is clearly beyond. So instead of the word clearly, you could say was adjudicated, was either clearly beyond or was adjudicated to be beyond. In that case, you'd go back to the concept that that person was found to have violated. So you can think about that.
But adjudicated,
So not, I use the word adjudicated, but what I meant determined. So somebody, you would throw in a sentence there that it was either clear or somehow the person, it was later determined that the person did, there was an abuse of force.
well, that may be the collateral estoppel issue, but
Yeah.
I mean, in this case,
Yeah.
you know, regardless, that it would have to be as determined by a reasonable officer under the circumstances taken
Mhm.
into account
Right.
and all of that.
So can you think of any way to phrase it so that the failure to intercede person isn't being decertified, whereas the person who actually used the force keeps their job?
I
Ja-
mean, again, I think we just have to work with the language that the legislature gave us.
Commissioner Long?
Yeah, just a question for Jackie or Maria, during the work group meetings, was work group A's under A, was that what they were after here? Were they bothered by this issue? Is that what they were trying to get at with their recommendation A? Do you recall what the conversation was or what the concern was with the law enforcement work group?
Yes, that's exactly correct.
And so then does that, for my police colleagues here, does A get at that to anyone's satisfaction?
I think one of the things that they were thinking about was if I fail to intercede, are my acts of doing so more egregious than the individual who actually is doing the actions themselves?
So then
So am I going to be punished more than the person who actually did that?
they proposed A, I assume, and
Correct.
I'm just asking my law enforcement colleagues whether they think A is sufficiently mitigates that or goes too far.
I think that speaks to what my concern was and clearly
Right.
what their concern was.
I think it's one of those, and I agree with Toby on this one. It's one of those, when we review the case here, that's what you start asking those questions. Because even later on, the person may have been found to be excessive force, but the witnessing officer didn't see some of the stuff. It goes back to what we talked about in the beginning part of the day. Yeah, there was excessive force later on determined, but I didn't see that because I was at a different angle. So I hate to put in language that says, oh, by the way, if it's determined to be excessive force, you should have interceded. When in fact, they didn't see it that way. So I think this is one of those, you, again, take case by case. And we may find a case where we determine that, yeah, they should have interceded and the agency didn't hold the employee accountable. We find that the agency was negligent, not doing their job because it was so egregious. We could see it all and they didn't do anything with it.
I'd also like to point out that under the prong, the third prong, the physical abuse prong, excessive or unreasonable use of force is one of the types of physical abuse that's potentially decertifying, but it's also much broader than that. So an officer could be decertified for physical abuse, including but not limited to excessive or unreasonable force. So you could make an argument actually that an officer could be decertified under the physical abuse prong under a much less of a physical circumstance than is required for the officer who's being decertified for failure to intercede, because that is only in a circumstance where he's witnessing force that's clearly beyond that which is necessary. So just the language is what it is.
Yeah, but it would be, back to Commissioner Gordon, it'd be a big red flag for me if we're hearing a case and we're listening to, they didn't intercede, but the agency didn't find that there was excessive force, nor did we find it. To me, that's like a no-brainer. Okay, then there was no duty to intercede because it wasn't excessive or necessary force. So the bottom line is I'm invoking the Donald Doctrine. What? Is there something above doctrine? I got to find another term. We started with amendment and now it's a doctrine.
It's alliterative.
So if we had that case though, and we made the determination, either the board or the commission, that the first officer with the excessive use of force wasn't excessive, then it's not clearly failure to intercede. So you can make the connection when you're adjudicating these things or making your decision.
Now, here's another circumstance that would be like that. Someone has a cell phone. The cell phone camera catches from the moment police officer B arrives on the scene. So the camera can show you what this person saw. Let's even assume it's the same angle and everything else. The average reasonable person would look at that video and say, failure to intercede. Later, we could determine what was before the video camera started. And so would we penalize someone for not intervening based upon what it is they saw? Or would we only do it based upon the end result? And we back to Donald. Because we'll have circumstances like that too.
Sounds like the chicken or the egg.
Okay, the other thing we can do with 9, as we could do with everything else, is discuss in our last piece of discussing, which is the overarching definition. We can always throw things in there that we didn't really see a good spot for, assuming we even wanted to keep that. Jackie, were you just brushing your hair?
No, I just had a thought and I'll just put it out here for your consideration. Keep in mind that all of these definitions, as broad as they are, is going to lend to interpretation by to the agencies, because it's the agency who will be interpreting this in order to report it to us. So the broader we go, the more interpretation there is, unless we receive information through other means, such as a public complaint, we find something in the media, any other additional way of obtaining the information, we will be relying solely on agency reporting. So the broader these are, the larger or the more room for interpretation you have, or the agencies have in reporting these to us. So we're going to have a lot of disparate reporting, likely based on the broadness of these definitions. And I just want to throw that out there. I'm not advocating one way or the other. Thank you. My hair is brushed. Thanks.
But correct me if I'm wrong. Somebody from the public complains about an event that they saw or experienced. We don't investigate that. We send it to the agency and say, hey, agency, investigate this and let us know within 10 days what your thoughts are.
Correct. The proposed regulations that are out for public comment, if I remember correctly, Jackie, there is a regulation that specifically states that we would forward that information to the agency upon receipt for their action.
So then
or
the
their-
agency, again, doesn't think it's a big deal. They tell us, no, we don't think this is a reason. Now we have a choice again about whether to investigate it further or not. Is that correct?
Yeah, that would be correct, assuming that this is coming to us through a public complaint, not a complaint that was levied or lodged directly with the employing agency.
Okay, so back, yes, Gordon?
Just a quick follow-up then, just for, I think, staff direction and helping us is, so specific to number 9, if we have a duty to intercede case, that should come with, more than likely, most of the time, with the excessive force case at the same time. So I think that would be helpful for us when looking at it, is this, that we provide that direction to staff that, you know, it should be one package that we're hearing both together. You know, unfortunately, they don't always get done together, but that would be, for me, kind of some direction on when it comes this way, how it should be packaged.
So for every case that comes to us with failure to intercede, we'd want to know what happened to the underlying case. Is that it, Judge? Yeah. Okay. Looks like no changes to 9. Now let's deal with the elephant in the living room of the overarching. So we'll go to page 1. So here we go. We don't have to have any overarching definition of serious misconduct. We can, and that gives us yet another avenue. I think just to start the discussion, I'd feel better knowing I had something that said, even if it's not one of the 9, if I still think as a commissioner, I want to explore that I would. I'd hate for us not to have that, for some case to come up that all of us feel, or most of us feel terrible about, and then they say because it doesn't fit into one of the 9, we can't consider it. So that's just opening for discussion. We can again have no overarching definition. We can have a very simple one. Or we can take pieces of workshop A and B and write one ourselves.
There was a suggestion at the end of the list of 9 of a 10 of neglect of duty that was brought forth.
What page are you on?
On page 9. Neglect of duty that was by either one or both of the work groups.
Hang on.
But not on this sheet, because maybe it was on the original one that I had. Oh, it's not on here. Interesting. So this is from the first version, Manny, that I had sent back with the work group. There was a recommendation to add a 10th definition of neglect of duty. And sorry, this was on version, I don't know which version this was, 1 or 2.
Okay, so just so we can all get literally on the same page.
I'll read it to
Okay.
you. This
Are
was,
you on page 9?
it's not on the page 9. It's on an
Okay.
earlier version that I
Okay,
printed
thank
out.
you.
but,
Go ahead.
So 10 neglect of duty, this term was added as a result of concerns brought forth by the work groups, which did not fall under one of the existing terms. The conduct is either intentional or a grossly negligent failure to exercise due diligence in the performance of a known official duty. So I don't know if that's something we want to add or not, but sorry, I was looking at an older version of this.
And I think the idea behind that was that based on some of the hypotheticals and the information that came from the work groups, that you could imagine a situation where, let's say, an officer, is in a situation where clearly medical aid should be rendered and yet fails to do it, and the circumstances are such that, it's clear that that it was a egregious intentional act of allowing somebody to be harmed. Or I think another example that I heard was officers that are ordered to respond to a scene and then choose to stay in the car and play video games, or intentionally refusing to go, let's say, back up another officer that they don't like, that kind of thing. Now, it may be that perhaps you could shoehorn that into bias if that was the circumstance, or some other one, but those are examples of circumstances where it might be a situation where it's pretty clear that everybody looking at it would say, yeah, that's pretty serious and we should look at that for decertification, but it did not fit within one of the 9. So I think that's how you can, I'm speaking because I didn't do this, but I seem to, my understanding is that that's kind of how that 10th one came up. So I guess the question is, the commission could either do this specific 10, or it could come up again with an overarching broader definition, which allows, circumstances like that to be picked up.
And it's not either or. You can do both.
Right, yeah, of course.
And I agree, there are circumstances that don't fall under this, but like officers that choose to hunt Pokemon, or but whatever that was instead of responding to calls there, or a negligent discharge that was so terrible or caused harm to someone, but wasn't intentional, but maybe that person just shouldn't be a peace officer. There's probably kind of a catch-all that doesn't fall under the other catch-all, that maybe that is a severe neglect of duty or some. conduct and becoming, or I don't know, but something for us to consider.
So Commissioner Braun, are you saying you would like to have an overarching definition?
I don't know. I just, we could throw it under serious to include these things, or add an additional category of neglect of duty or conduct unbecoming, or something to that.
Okay, Jackie, did you have something? No, Maria? You're waiting until tomorrow? Okay. Commissioner Long.
Toby, could I ask you, I mean, do you see workshop B's catch-all for serious misconduct? Do you see that as a viable?
I'm sorry, the definition, the catch-all definition?
Yeah, and under serious misconduct, workshop B, do you see that as a workable, credible catch-all that you've been referring to?
So let me give my thoughts on that. So there are a number of elements of this that I actually like.
Toby's your.
Oh, sorry. Yeah, there are a number of elements of this that I liked. The one thing though I understand the intention behind some of the language that's in here. The one thing that I was thinking, since I've prosecuted these cases and I know what it would take to actually put this case on before the commissioner, before an ALJ, is as a lawyer, I have to look to how do I prove some of this, right? And so unconstitutional, I probably know what that is. Harmful or neglectful act, that's a little bit more difficult to understand what that means. And then a violation of law, okay, or agency policy, okay. But then things like a failure to uphold community standards. So what community standards are we talking about? That's the question. How do I prove that? And then if we are relating community standards, it may be that a community standard in LA is different than a community standard in Reading, but does the commission want to incorporate community standards in this definition since it's decertification statewide? Those are the things I think the commission needs to think about. And then ethical and professional standards, that's the only question I have as a lawyer. Again, is the question is, how do we prove it? What ethical standards? Are we talking about the Peace Officer Code of Ethics? Well, if that's what we're talking about, we should put that up here and make sure that we want to decertify people and how we would prove that. And then professional standards, I'm not 100% sure I know exactly what we would mean by that. I do like, because ultimately the last clause really is what the case law says. And the case law says that in order to take away somebody's ability to practice in a profession, you need to be able to show that the underlying conduct is such that it demonstrates a lack of fitness. In some cases, say fitness or competence to practice in the profession. So I like that part of it. The other parts of it, again, it's just a question of they're a little bit ambiguous. I'm not sure what they mean. And I don't want to be, as a lawyer prosecuting this case, I don't want to be bound to something that I don't understand what it is. So I can't prove it if I don't understand what it is.
And I think if we go with the concept of the overarching definition, we want that to be as broad as possible, because we don't want people starting to think that a defense would be that's within the community standards, or that's ethical according to blah, 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 or professional. I would take away all those words and just leave it very broad. Yes, Judge.
So if we went with having a definition, would we take what is, I mean, maybe with some, a few changes for workshop A, but then add reflects a lack of fitness to serve as a peace officer in the state of California? Because you could say the 9,
Right.
and that gives you that Commissioner Braun was talking about, where they don't necessarily fit into a category, but they have no business being a peace officer in the state of California. So I'm just trying to figure out if, versus adding a 10th or going down that road, how do we take that language and put it into the definition to have that?
So
that's just a thought.
So if I may, if it's okay.
Please.
So my thought on the workshop A was that it in and of itself didn't add really much. In fact, it didn't really add anything, because it just says serious misconduct is one of the 9 criteria. And then I would never recommend that we say may prompt a review to determine, because how do I prove that? So So instead of having, if we want to go with workshop A, then we just say serious misconduct is, and then we jump into the 9. That's really what A does, and that's all we would need to do if the commission wants to go that way. If we go into B, I think we can do what you're talking about by having the overarching definition that says it's an act or omission that, you know, reflects the lack of fitness or competence to serve as a peace officer, and then can say including, and then you include the 9 within it.
But I think you'd say including but not limited to.
Sure. Yeah. And the only question, the only thing we have to, and I think we could probably do that. We'd have to wordsmith the language a little bit, but the only thing you have to be careful of is that you don't want to have a rule or regulation that's so vague that an individual can say, I did not know when I did this act, that by engaging in this act, it would be something that could result me in losing my ability to practice as a peace officer in California. I think, though, the cases have said, look, you know, let's look at this fact pattern. Any reasonable peace officer or professional would have understand that that conduct is going to demonstrate your lack of fitness to serve as a teacher, you know, whatever it might be. So it might very well be that we can come up with language along these lines about the lack of fitness, and then include the 9 and have it in a way that it would withhold, you know, due process scrutiny if somebody were to appeal it. I hope that made sense.
Madam Chair,
Yes.
just on that, I would actually agree with the former. You just keep it simple.
Mhm.
Serious misconduct, and it's the 9. And I think to address your concerns, and Commissioner Prong's, you look at 6, and you know, acts that are inconsistent with a peace officer's obligation to uphold the law or have respect for the rights of members of the public. I think that, as we discussed it when we got to number 6, is the catch-all.
Okay, other comments? I know that Maria still wants to speak, but I haven't forgotten her. But she doesn't wanna-
If we are going to go with a definition, like workshop A, serious misconduct is conduct law, should we add the word sustained or proven conduct? I mean, it seems redundant that it would have come to us, but
Well, we would have to prove it, obviously, in order for the action to go forward. But the sustained misconduct, that really comes from the Senate Bill 1421 language. And that was the question as to whether or not, you know, it should be made available to the public. And that was only if it was a sustained finding. I'm not sure we want to limit it to sustained findings. I think the whole idea here is that the agency may not sustain it, but we may nevertheless feel that the conduct warrants a decertification, or it may be a circumstance where the agency doesn't do an investigation at all. So it's not sustained, right?
So so that possible broad statement would be any act that, so serious misconduct is any act that reflects a lack of fitness to serve as a peace officer in the state of California, whether on duty or off duty, including but not limited to the following. Feel free to break into applause. Thank you, Commissioner Yule. I'll take a thumbs up rather than applause. Let me read that again while you guys consider it. Any act, and I'm incorporating workshop B's language to this, any act that reflects a lack of fitness to serve as a peace officer in the state of California, whether on duty or off duty, including but not limited to the following. Now, the problem I see with that statement is that's pretty vague.
It is.
Is it too vague?
It probably is, yeah.
Is there anything you can do to that statement to keep it broad but not vague?
Madam Chair, I'd walk carefully with using fitness as a word. For nomenclature in this realm, you're bringing a different realm in that might be a challenge.
Mhm.
Obviously, you're the legal eagles, not me, but it could be misconstrued by, you know, police officers or chiefs or sheriffs.
Yeah.
I agree, because that could bring in physical fitness, which could be problematic.
I completely understand that concern because peace officers particularly think fitness means fitness for duty, right? The term really comes from a body of law in California involving professional discipline. And what the courts have said is that to ensure, constitutionality of these sorts of disciplinary acts, it prohibits or it requires license revocation if you can show that the licensee's conduct relates to fitness or competence to practice the profession. So that I think really is where it comes from. It's the case is saying in order for disciplinary action to be upheld, it has to be conduct which you can show reflects a lack of fitness or competence to be, in this case, a peace officer. So I think that's where the language.
You could, if you're looking to avoid the fitness, but you still wanted a general statement, it would be any act that reflects a lack of competence to serve as a peace officer. But again, very vague. Commissioner Long, Barcelona, Brazil.
I was just going to say, Toby, I like the workshop B wordsmith, as you pointed out, to maybe just lose the demonstrating officer's failure to uphold community, ethical, and professional.
Jeff, you're looking down and so I'm having trouble hearing
Oh,
you.
I'm sorry. Just getting rid of some of the wordage, Toby, that you had a problem with there, specifically the failure to uphold community, ethical, and professional standards. Can't you wouldn't we be able to work with B pretty effectively? It
What
seems
is
like
it you'd want to have in there? I understand what you want to take out. What do you want to have in there, if anything?
without regard to whether such conduct would constitute a crime, including unconstitutional, harmful, and neglectful acts of misconduct or violation of law, and reflects a lack of fitness to serve. That was what I thought would work best, but then I'm somewhat persuaded by Barry's point that a lot of this is already in catch-all 6.
Okay, let's go to Commissioner Brazil.
Yeah, I'm in favor of an overarching catch-all because there's some provisions in here that wouldn't necessarily be caught. Having worked with another agency where some employees did some things overseas that were legal in that country, but highly illegal here, that isn't caught in here in this, nor are some of the things that happen in the military where the military refuses to cooperate with investigations, but we become aware of them. So I think we do need a catch-all, but it's, and again, the language, that's where Toby gets paid the big bucks, joking, as to how do we craft it that gives us enough authority to look at something, but isn't so broad that it doesn't mean anything.
Right.
Barcelona?
I wanted clarification what he just said. So were you suggesting that something that occurred in a foreign country that was legal, but illegal here, we would go after the officer for it? Would I hear you wrong?
Oh, I think there's some things that, yes, we would.
Well, give me some examples.
Narcotic use, sex with minors. I can go on and on and on, but you hear some of the things that are not crimes in other countries that definitely show that they're not fit to be a peace officer in this.
Human trafficking.
Yeah.
So, but what about, we've got people who come over here, immigrate here, and then they become, a police, a citizen and a police officer here. And then someone comes along and says, oh yeah, in Iran or wherever they're from, this person, married someone, 14 or whatever, or something like that, that then we would go back and we would go back in their history there and remove them.
No, I'm not.
Even though it's a
suggesting that at all.
cultural thing there, I think we're opening Pandora's box to some of that stuff.
I think there's a big difference when somebody comes, what somebody does after becoming a peace officer and taking the oath of office and understanding the roles and responsibilities different than what.
So it would be afterward. It would be after that?
Yeah, this is a current employee that goes off and does.
Okay,
I just want that catch-all that if we come across that they're doing something that definitely would be illegal here while they're peace officers, but there's no crime committed in that country, but would be if it was committed here. We need to have the option to look at it. These are gonna be rare cases, but I just flashed an agency I'm working with. It's like, holy cow.
Well, and actually in Government Code 1029, there are some provisions in Government Code 1029 that do talk about conduct committed outside of California that would have been a violation of California law if committed within the state of.
But it's after they're peace officers. I'm just talking about, we have a lot of people now who come from foreign countries and become citizens. And are we talking about that conduct when they came from their original country and, prior to being a peace officer here as well? Or is it just after they become a peace officer?
I think with Toby, what you were talking about with 1029, it's disqualifiers from serving as a peace
Right.
officer.
Correct. Yes.
So if things came to light from prior, after they become a peace officer, then we would do that. We would be looking into doing an investigation on those things.
Well, yeah, we would have to, with each of these cases, it gets very complicated under 1029. Manny and I have gone through
Uh-huh.
a number of those circumstances. It gets very complicated. So really, I think what I'd have to have is a factual situation, and then I'd have to look at the statute and see if it applied or didn't. Yeah.
Okay. I just have members that are pretty much from all walks of life, from all foreign countries, and they become citizens, and now they're investigators with the state. And this is kind of I've never thought about that before. I haven't had this issue, but sounds like we might have this issue now with licensing. So it's concerning. It'd be nice to know whether it's going to be all encompassing prior and after, or just after you're a peace officer.
Madam Chair.
It's interesting. Just, we can talk about, I'm happy to talk to you about section 1029 separately. It's a very complicated statute, but there are a number of provisions with respect to conduct committed in another state or jurisdiction, which would be a felony or a violation of California law that could potentially be a ground for.
Okay, so it's all encompassing then,
Yeah.
before being a peace officer. Doesn't matter.
Let me talk to you about it separately.
Okay, thank you.
I think the rest of us would be interested though. So after this conversation, if you could bring it to our attention. So I think the question that Commissioner Barcelona is asking is, so someone, let's say domestic violence is lawful in another country, and someone's going through a divorce and they've committed no acts of domestic violence in this country, but in the divorce, the person they're divorcing says, and he used to beat me up all the time in Guatemala, making all this up. Then could that be cause? Is that an example? Okay. Okay. I didn't ask it. He did. I just gave you the graphic description.
Madam
Okay.
Chair?
Yes, Commissioner Yule.
I don't want to move too far. Well, first of all, I agree wholeheartedly with an overarching
You agree
definition,
wholeheartedly
with an overarching definition being added. But I don't want to move too far away from your original language. And it just seems to me, and certainly out of understanding what Mr. Donald had stated regarding fitness, that there can be some wordsmithing there. But I think that that's the perfect framework, quite frankly, and then just do the wordsmithing, but make that the overarching
Yeah. I think
definition.
we're all looking for something that's not too broad. It gives us flexibility in a situation where we all agree the behavior was outrageous, but it's not one of the 9 that we can't quite wrap our heads around now. But when we see it, we'll know that that's what it is.
That's the perfect framework to begin and then come back with recommendations, quite
Okay.
frankly.
Maria, now?
Yeah, I have great angst over this conversation. And the reason why is because we're facing some serious time issues when it comes to OAL. We were hoping that we could have you all wordsmith this to try and come back to you with A, B, C, and you pick something we don't even have, D, E, or F. That's going to be somewhat problematic for us. And for the January 1st deadline is one of my concern is. So I was hoping that one of the main things that you guys are going to deal with today is define that and what the commission wants, where the commission wants to go, and to give us what you want, and then we could incorporate that into regulation. I'm just concerned about the time restraints. And I don't know if Katie has that information and when that needs to be done, or I don't want to put her on the spot, but it's just, that's a main concern for staff.
That's very reasonable. And I think we shouldn't leave here today until we give you that. Okay. We're gonna do the best we can. So I think there's a feeling in general that we want to have an overarching definition. But let's start with that. Who, I'm going to ask for a show of hands about who wants one and who doesn't want one, just so I can know whether we should now spend the rest of this time creating one or not. So who would like to have an overarching definition of serious misconduct?
I'm going to have to break from the Donnelly Accord and say
I
I'd like
think-
one this
okay.
time.
So 1, 2, 3, 4, 5, 6, 7. 7. Once again, it's that magic 7. Okay, so now we're going to try to do what's been asked of us, which is we're going to try to come up with the wording on that. Toby, I'm going to ask you to listen carefully to make sure that whatever we come up with isn't too broad, which makes it completely useless. But at the same time, when all of us have this feeling of an act should definitely decertify somebody, but it just didn't happen to fit into those 9, we all say, yes, this is it, because we don't want to be the people who saw this horrible behavior and said, nothing we can do about it because it wasn't one of the 9. So, break? Good time for a break. Okay, we'll start again at 2:15. Put some thought into that one. What, that other language that Ingrid was talking about, where did that come from?
I don't know.
Oh.
What language?
Ingrid, do you have that language that you read to us out loud? Can I see that again?
Oh, sorry. That was
That's
the-
right.
That was the prior version.
Yeah. I'm just wondering if I can come up with anything from that.
So I had printed this earlier one and I was going through it and there was a find and replace where work groups was, so he's got my notes all over it. So I'd let Mandy know about it and so then I revised it. So I don't know where that one went. But
So that one?
Yeah.
Okay.
since the work
Yeah, but
Groups
the
was
groups,
replaced with
which is not phone. Okay, so this is a sentence, Toby. This is the sentence that maybe, oh, I'm sorry, Jeff. I didn't see you standing there, Jeff. You're too tiny. The conduct is either intentional or grossly negligent failure to exercise due diligence in the performance of a known official.
Well, yeah, that's for this neglect concept.
Okay, but I'm saying, could that be the sentence we can start with for a definition of serious misconduct?
Well,
Toby and I worked on this a little bit, and we came up with this, but I'm not going to blame Toby, I'll blame me. I came up with this. So let's take a look at that. I think there are some people who feel strongly, and I'm going to put myself in that category, who feel that we need to have a catch-all for all the reasons you can imagine. And we're trying to find a catch-all that can potentially work. So this would be at the very beginning. Serious misconduct, acts or omissions, and we may have to say omissions to act, but act or omissions demonstrating a lack of fitness or competence to serve as a police officer in the state of California. Now, the reason even though there is the concern about fitness, it is a term of art, it's also a term of law, and it's also a term that's used in law enforcement, not for the size of somebody or how healthy they are. It really is a term about whether they can perform their duties. So acts or omissions demonstrating a lack of fitness or competence to serve as a police officer in the state of California. Serious misconduct includes, but is not limited to, the following. Okay, tear it apart. Okay, hang on, one at a time. What was that?
I was gonna say, could you just change ability with fitness, lack of ability?
Toby, fitness is a term we need to use.
Well, again, the reason that I came down on fitness is because that's the term that's in the case law. The nexus is that the conduct demonstrates that they are not fit to practice the profession. Ability, I think of ability more aligned with competence almost.
I think of ability is potentially very dangerous because if
Yeah.
someone has a disability, then we say we don't
Right.
have an ability. So
Right.
does that mean we're not going to hire people with disabilities
Right.
or blame them for their disabilities?
I think that really we are, I mean, as difficult as I understand the term is, we really are looking at the question of, look at these facts, is this person fit to serve as a cop? And that's really the question that we're looking at.
And Toby, just to finish up in the legal, should it be acts or omissions to act or just act or omissions?
Sorry, oh, you're saying should it be acts or omissions to act? I think just acts or omissions is sufficient, I think.
Oh. Okay, come on, everybody. It's the last thing we have to talk about today. Commissioner Yule?
There,
So let's go to Commissioner Yule first and then to Commissioner Braun.
Again, I support the language that's listed there. I think it's important. I mean, people argued about too vague, but I think you need that catch-all so that you're not just assigning your name to something and then having people walk through and say it didn't meet these 9 criteria, therefore I'm free, and I have no responsibility and we have no jurisdiction at that point. So I like the vagueness and I like the language that's there and I support it.
Thank you. Commissioner Braun?
I like the language just as a former police officer who has trouble breaking the habit of saying police officer. It should be peace officer.
Yeah.
I agree with that.
Yeah, I agree. I was stuttering over that one both times I read it out loud. Other thoughts?
Yeah.
How about thoughts from those of you that didn't think we needed a catch-all?
Yeah, I go back to what my original, and it's the Donald Doctrine.
Oh, my God,
Toby,
please.
You got that, man, when you do your writing? Good.
You're gonna go home tonight and tell your significant other, I have a doctrine named after me, aren't
I
you?
do, I'm actually going to do
I know
that.
you are. I know you are.
As chair, you will hear
Be
that
on the phone and I will
regularly
say, no.
moving forward.
It is now enshrined in post jurisprudence.
It's awesome.
Commissioner, you don't want it there.
Well, I have no problem with this.
Okay. Oh, okay.
It'll work. It'll work. I mean, my concern about fitness has nothing to do with the framework we're in. I understand the term of art. I accept your explanation. I worry about the challenge it poses from just a language perspective in the profession more than anything else. But in its context, I'm fine.
And do you think we need an overall definition of serious misconduct at all?
My original position was that you have it by virtue of the legislation, but this doesn't impact it in any way, shape, or form. And, it clarifies it in some way.
Okay, Commissioner O'Rourke, what are you thinking?
Well, just based on the bill and all that, we're here to let's see, establish the criteria. I get we can add to it. I get the statement there. I think we've done that with these 9 categories. And I think there's pretty much a catch-all in all those sections. So overall, I don't think we need a statement, but I get it and I see what the room's saying, so.
Okay. And Commissioner Braun, you've expressed your views, and Commissioner Yule, you have Commissioner Gordon,
I'm very comfortable with this definition.
Commissioner Long, Commissioner Brazil,
I'm good.
Commissioner Nito.
Again, I broke from the accord on this one because I do think that we do need a catch-all because it's surprising what people can do sometimes. And there's going to be that one case that may not fit the 9 definitions, even though they're fairly broad.
Commissioner Barcelona?
Yeah, I think that it was good just the way it was written, but what you've added doesn't change that. So I'm okay with it.
It'll be so interesting for me to see where we are January 24, to see how many more times we had to pull this up. Now,
One last thing, what's nice about the Donald, I forget, what is it? The Donald document? Yeah, doctrine, is that if this all goes south, we have someone to blame it on.
and years from now, people are going, who is this guy Donald? Yes.
Madam Chair, if I may, so one of our staff members has pointed out the term fitness, should it be suitability, or do you want to leave it at fitness?
Suitability.
Madam Chair, I can't speak on legal, but from my perspective, that would solve the challenge I view in the nomenclature used in the profession.
You like suitability.
Yeah, absolutely.
Yeah, I think that I think that the courts would ultimately look at the question of whether it demonstrated a lack of fitness, but I mean, I think suitability, we could
Yeah.
probably do that with the understanding that the courts would understand that we were looking at the question of whether or not they were fit. I think fitness and suitability is probably sufficiently similar when we're talking about the legislative intent behind the enactment of the regulation. Yeah.
It's funny because when I go to this start and see the whole thing, I think I want to use language that people have used before because then there's no potential for confusion. But when I heard suitability, I thought, ooh, that could work. And I think if it takes away some of the anxiety, it's saying the same thing to a layperson. Are you pausing or are you done?
Well, yeah, I still do feel that, your suitability is, I mean, just as a lawyer, it seems like there's a difference between your suitability for a job and your fitness to serve in that position.
So
But
I just wanted to bring up the point because we've focused on the physical aspect of fitness. But typically the other portion of this, when we talk about fitness for duty, we're talking about whether they are mentally able to perform the job anymore.
Yeah.
And I would hate for this to become part of that. So I understand your point with, the court and all this type of thing, but, in really thinking through using the term fitness, I would be way more comfortable using suitability now that there is another alternative, because the more I think through what lack of fitness means, if we can
But to
convince
me,
Toby in his legal mind that suitability is okay.
but hearing you say it, I became alarmed, and it's someone could be suitable for a position, but not fit. And so I interview somebody, and I think, well, they're suitable, and then they do it for a couple of months, I go, they're not fit for this position. So suitable to me isn't so I'm back to fitness.
well, how about this? Can you say fitness, suitability, or competence?
I have a question. I think the question's for staff. When in the hiring process, what's the language we use when we're evaluating brand new people coming in? Do we call it suitability for law enforcement? What is there any buzzword we use in the background process that sets the stage? Or do we just need to look at it and come back?
That term is actually being suggested by somebody who is in that arena that deals with appointments and the backgrounds and all of that. That's the language
I
that
kind
you
of assumed that was
suggested.
kind of what it was. where we're coming
Perhaps we
from. I
can-
think that way we're
We can
consistent.
see if she's downstairs and she could articulate the language. Melanie Singley, if she's downstairs.
Because I'm not the lawyer, but I think if we can loop it back to the minimum requirements and all the stuff, I was pulling up language and why we're looking. And the code of ethics that we had a lot of conversations here at this commission. And I couldn't find any language there that would fit in here. So I was looking for how do we tie what we do and other things and qualifications and looking at to here.
Yeah.
Our background individuals in the building, so the bureau chief is going down to fetch her.
Will you let her know I'm apologizing publicly now for
Does that seem lower to you? It seems lower to me. You know, when someone's about to go out on a blind date with someone and they say, well, tell me about them. Well, they're suitable.
don't go on the date.
Fits lower than.
It is late, but I also think that suitable's kind of a little lower than maybe fit, you know, mentally fit, physically fit, psychologically fit, intellectually fit. All right, bring them on. Suitable, no thanks.
Qualified, unqualified?
Qualified is like suitable. I want to know that they're more than that. Okay, we have the Dudley Doctrine of who you go on a blind date with. So what is your thinking right now about fit, suitable, ability?
I do have one, I'm just pulling up the psychological evaluation report for somebody to enter into law enforcement. It is suitability declaration to be maintained in the background investigation file. So it is referred to
As suitable.
as suitability.
Okay.
Suitable, correct.
Yeah, it strikes me that it's a little bit of a different inquiry. I mean, maybe it is, maybe it isn't, but the question is whether or not an individual who's not presently serving as a peace officer has all of the requisite background and psychological qualifications and physical qualifications. So they're suitable to be employed as a peace officer. But then once they are employed as a peace officer, if you engage in conduct, you might still be suitable. You might still be qualified and physically fit and mentally fit and all that stuff. So you might be suitable to
There she is, I see.
to be employed as a peace officer, but you've demonstrated conduct that that itself, the conduct demonstrates that you should not serve as a peace officer in California. But anyway, I see our.
Because you're unfit.
Right.
Welcome.
Hello. I'm Melanie Singley, Selection Standards Program.
I'm sorry.
I'm Melanie Singley with Standards and Evaluation Bureau.
Thank you.
Standards, Strategic Communications. So I just recommended suitability because we do use it in current regulation 1953 for background investigations. We use it for med psych, so all of that.
Besides background investigations, are there any other times that you're aware of using suitability versus fitness for duty, either one of them?
The only time I've heard fitness is for fitness for duty evaluations. And that's in, state law. They talk about fitness for duty and it.
That's when someone's been a police officer, takes a break, and then we don't put them back in being a police officer until we can prove that they're fit for duty.
Right. And that's been exclusive to medical as far as it's been considered for, at least for peace officer.
Medical and psychological.
Right.
Okay, but it's, okay.
And I think that's just the issue with the term fitness is more of a medical term than suitability. Suitability kind of covers all of that. When you look at the definitions and you look at all the similar terms, it's a wide range of things. So that was just a suggestion because fitness, to me, it's the same thing. It brings up
Okay.
medical issues.
Okay, good, thank you. Any other questions? Thank you. Free to go. Or stay. All right, so show of hands. We're down to the show of hands now. How many would like to have acts of omissions demonstrating a lack of suitability or competence? So hands for suitability. 1, 2, 3, 4, 5, 6. Okay, suitability wins. So we will take out the word fitness and demonstrating a lack of suitability.
I would just suggest between now and May, because we're voting on this in May, correct?
Yes.
is that if Toby identifies something, says, you know what, we gotta go with the legal term because it will help us defend it, that
Okay.
it's brought back to us for those reasons, because I also understand we have to defend this if we decide to bring something forward, so.
So let me give it to Marie in the form she likes it.
Madam
A.
Chair,
Oh, yes, please, Jackie.
sorry to throw a curveball into this. Thank you, Maria, my assistant. SB 2 does specifically say that the bill grants the commission the power to investigate and determine the fitness of any person to serve as a peace officer.
We're so glad you brought that up.
I turn it back over to you. Thank you.
And I did notice Toby's big smile over there when she read that, so.
Perhaps we can go back, because again, I mean, listen, I'm an employment lawyer. I understand the concerns about, fitness for duty, and we certainly don't want to make it look like we are, proffering a statute that looks at that. That's certainly not our regulation that looks at that. We're certainly not. So it really is a term of art. I mean, maybe can we go back to fitness, suitability, or competence?
Yes, so let's start it with fitness, lack of fitness, comma, suitability or competence.
Okay, I'm gonna be the squeaky wheel now. Does that now highlight it to be fitness for duty, physical, by separating it out? To me, that means that actually makes it look like it's a fitness for duty.
Really, you think so? Yeah.
That's just me, though. I'm not the lawyer. It just,
Yeah.
Okay. So suitability is disappearing entirely again? Fitness of duty? Lack of fitness for duty, of duty? What was the term again in the paper? Was it fitness for or fitness of?
I'm sorry, can you repeat that?
Sure. Jackie, you read us something?
Oh.
And they used the word fitness. Was it for or
Yes.
of?
Yes, my apologies. So the SB 2 reads, the bill would grant the commission the power to investigate and determine the fitness of any person to serve as a peace officer in this state.
Just the word fitness then?
Correct,
No of or for?
correct.
So fitness, lack of fitness or competence. Take out suitability just for the moment. We may put it back in just for the heck of it. Okay. Now, Rick, what do you think?
I'm thinking, what was, I'd almost mirror the language as best we can that fits in that sentence that's in that.
So you're saying.
Get rid of competence. Yeah, I would mirror the language as best we could since it's in there. That's just because I don't know from a lawyer's perspective, that's the legislature saying you're allowed to go, whatever that language was, investigate for fitness for duty. That's our direction to the commission. Boom, this is what we're doing.
Okay, would
Right,
you
and-
take out competence for a moment? Just so we can all look at it. Yes, please.
And I came up with that again, only because that's what the cases say, is, the question sort of in the blind is, let's say you've got an entity that regulates professionals, whatever group of professionals you want to talk about. And that entity is presented with a series of facts and then takes action against an individual and removes their ability to practice in that profession. The courts will look at it and say, do these to comport with due process, does it show that did these facts show that you lack fitness or competence to be in practice in the profession? And if it does, then the courts will say, okay, that's sufficient for purposes of due process. So honestly, what I was thinking in terms of competence was, it may be, to me, this is just to me, what you guys think about it, but if we had a set of facts that was really a competence issue and not a fitness issue, that may be something that the commission would ultimately decide not to decertify for. Maybe you'd suspend and then require retraining or something like that if it was for competence. So if you want to leave it as a lack of fitness, then, you can certainly do that.
But if we're going with the definition under SB 2, you almost have to take competence out because that is incorporated within what fitness is, because otherwise you're separating it out into what we would understand fitness to normally be within the profession. We all have fitness for duty policies that are very specific. That's how in which we send someone for a fitness for duty examination. So if we're going to be consistent with it, I don't think we can separate competence out from fitness because we need that all encompassing definition that is given to us within SB 2. Because if we're not going to honor what's in SB 2, then I would say we shouldn't use the term fitness. But if we're gonna honor what's in SB two, then I would say we leave it as fitness without competence, so that there's no question as to what that means.
Okay. So right now, this is what we have. So by a show of hands, do you want to keep exactly what we have? That's vote one. And vote two would be, do you want to change it? So then you'll have to tell us how you'd like to change it. So as it's written now, show of hands if it's acceptable to you. Okay, that would be everybody. So full speed ahead. So Maria C., we did it. I'm not sure it was helpful, but we did it at least. Maria, given what you brought up, you've been here the whole day. Were there other places where you think we were expecting too much of staff and saying, well, we'll see if staff can come up with something better? Because we could stay longer. We could stay longer and try to get to the bottom of it. I understand your
I think
concerns.
that the rest of it, I think that's something we can kind of hammer out as a group. It was just the overarching definition, I think, is what we did not want to travel down the wrong path,
Okay,
delay the process. So thank you for that.
okay. So I expected to go to 5, so the rest of you just mind staying for another? Anything else about this that just isn't feeling quite right? That the way you kind of, your expectations for how today would go versus how today went? Any issue you want to bring up again? Hearing nothing, I will say, I will look forward to seeing all of you in May. Oh, there's more to it. There's a script. But I also want to remind everybody that May is a 3-day meeting. So some of you may be wanting to come in the Monday night before and make your reservations for Monday, Tuesday, Wednesday. And now I'm going to read the script.
May I explain?
Please. Also, didn't we want to talk about one of the meetings?
Yes.
Yes. Okay,
So,
please.
yes, in terms of the meetings on the 24th, 25th, and 26th, just as a reminder, how we were doing it is the 24th in the afternoon, the advisory group will meet to address these agenda items because they'll be in the public agenda. So that's the advisory group. That's not the commission. And they're going to look at everything that was done today and give their recommendation. So that is on Tuesday.
Was fitness, excuse me, finance also on Tuesday? Okay, just advisory.
So just advisory. And then on Wednesday morning, we anticipate Wednesday morning, correct, all day to go over all of the SB2 regulations and anything SB2 related. Obviously, we'll have all the 21 regulations that are out for public comment now, plus this one for you all to review and perhaps some others. But that's the crux of it, those. And then on Thursday morning, we will come back first thing in the morning and have the regular commission meeting.
Finance first.
Well, yep, we'll start with finance and then we'll have the commission meeting on Thursday morning. We don't anticipate that'll be super long because obviously we'll have all the SB2 stuff on Wednesday and we'll be done. We'll do all the formalities on Thursday with the honor guard, hopefully recognizing Commissioner Bowie, hopefully have a chief's welcoming remarks. So that'll be the regular meeting, but we didn't know how much time and effort was going to be needed for SB2. So we wanted to carve out a day because we knew generally you're going to have to spend the night anyway for those that are traveling. So that would be that Wednesday night.
So this is April 8th and we're talking about May 24th. So obviously we have some time in between. Right now, based upon everything you know, what time would you guess the meeting on Thursday would end?
1 o'clock, I would say.
1 o'clock,
yes.
okay. So just let us know if more things keep getting added to the agenda and we look like it's going to be a prolonged day. That's
Okay,
all.
yeah,
And-
we will know
Things come up.
as we get closer. We don't have a lot of agenda
Okay.
items I don't anticipate for May that are non-SB2 related,
Mhm.
but we do have the awards ceremony
Right.
and we do, do all the other stuff and that could
Okay.
take 45 minutes, as you know.
And do you also want to talk about September 22nd?
Yes. So the last meeting and the agenda in the last meeting had a date in August. We had some troubles, some difficulties finding reasonable accommodations at the state rate at the end of August. So we took the liberty in discussion with the chair of moving the meeting to September 22nd. That is the roundtable meeting that we've had for the last 2 years, where we try not to put a lot of commission agenda items through that meeting in August, September, where you all can deliberate, discuss, give us direction. It's more of a roundtable discussion in terms of not, going to a ton of agenda items, hopefully none. They're all consent items. So that's in September, and that'll be in San Diego.
So just to be clear, on September 22nd, we'd have finance and advisory in the morning, or what are you thinking?
In September,
September.
I believe it is just the commission.
So
That's
no
all.
finance and no advisory.
No advisory, no finance, correct.
You said that one's in San Diego?
Yes.
I've never heard of a commission meeting without a finance. It's a different kind of meeting.
Yeah, it's a
Okay.
work, I think this was I'll give credit to Commissioner Long.
Okay,
Because 3 years ago, he asked for,
Okay.
if you remember Commissioner
Yeah.
Long, a meeting to discuss. We're just prepping you guys for
Okay.
next year, because we're going to schedule one of these every 2 weeks based on everything we did today.
so then
so-
people will just need a place to stay on September 21st out of town, but everyone will be gone by the end of the day on the 22nd.
Correct.
Okay.
Obviously, I believe we're allowing and setting up the reservations for 2 nights for those that need to. We're not going to require somebody to
Sure,
come
sure.
work from 9 to 5 and then take a flight at 9 o'clock.
Exactly.
They
Okay.
want to fly home, so be it, or travel home.
Okay. Any comments about the last 2 things that Mandy told us about? Okay, let me read a little more. As this was back to serious misconduct, as this was the last item on the consent agenda, is there a motion to approve the consent items? Thank you. Any questions, comments? That motion passes. We just again, to go over the upcoming meetings, May 24th through 26th, the 3-day meeting is up here. September 22nd is a special meeting down in San Diego. November 30th through December 1st, 2022 is back up here in West Sacramento. March 1st, 2023 through March 2nd is TBD. June 7th through June 8th, 2023 will be back in West Sacramento. Manny, is there anything else?
Not from me, no. Thank you.
Okay. Commissioners, anything else? Okay. Great work, everyone. Tremendous work, tremendous listening, communicating. I think we got some great things done today. Thank you all. What's that?
Thank you very much. I think a lot of us are concerned we'd be herding squirrels today, and you did a magnificent job of herding the squirrels. Thank you very much, Madam Chair.
You're welcome.